My name is Agnieszka Samborska. I am attorney at law and partner in a case legal Poland. First of all, welcome everyone. We are very happy that you are here. I would like to ask whether you hear me and see me, but you know, the view, it's not the important. Whether you see the presentation, please let me know on the chat. Okay, great. Thank you. Thank you for confirmation. Then let's start the event. Firstly, a few informations. The presentations will be available. We will send it to all of the participants, as well as the recordings of this of our webinar. If you have any questions, please let them know on the chat during the presentation. If there will be time in the end, I will try to answer all of this. If not, then we will prepare a summary of questions, and we will answer them in writing. The topic. So let's move to the webinar. I have already introduced myself, and let's introduce the topic, which is the pay transparency compliance in Poland. And also we will speak not only about the provisions of the directive, but also about the project of Polish statute, which should implement the directive. Few questions, few information about me. I am attorney at law, working for a case for over 15 years right now, and I am specializing in labor law and also in corporate and civil law matters. In our legal office, we are taking care of basically all legal advisory matters, maybe besides the criminal law, but we are ready to answer many of legal questions, including also the court disputes, mainly labor law advisory, corporate advisory, establishment of companies, but also mergers and acquisitions, due diligence cases. And we are fully operating legal office in Poland, but we also have payroll and our accounting services, tax advisory, and we are also present in other countries in Europe, for example, in Czechia, Slovakia, and Hungary. So that was a short introduction of me and of the company. Let's move to the topic of our webinar. So first of all, shortly about the directive, why it was introduced into the EU. So as you may know, there is a pay gap between the remuneration of men and women, and the directive it was implemented firstly because of this pay gap, to equal the remuneration of men and women for the work of the same value, or for the same work, and this is it's included in the name of the directive. Well, the pay gap varies between the countries. Like in the whole Europe, it is said that it's about 7-8%, but in case of the specialized job positions, so higher job positions, the pay gap it's much higher, and in some cases it reaches about 20%. So this is significant difference between the pay of men and women for the same work or work of the same value. The directive says about the differences between the remuneration of men and women, but in practice it influence the differences also between the employees of the same gender, because the mechanism of the directive, they strengthen the non-discriminatory rules in general, not only in case of the remuneration of men and women. And for the member states, the crucial and the most important obligation is to take the necessary measures to ensure that employers have pay structures that provide equal pay for equal work or work of equal value. So this is what I've just said. Yes, it's not only about the gender differences, but about the differences between all the employees. So the directive should be implemented by 7 June 2026. In few seconds, I will tell you how is the situation right now, how looks the situation right now in Poland. Just shortly, purpose about the directive, as I said, it's to reduce the gender pay gap, ensure equal pay for equal work or work of equal value, but also increase the transparency in pay structures. And what is important, because if we have provisions but we do not have any enforcement mechanism, then we can say that the provisions are dead. So also the directive, it imposes the obligations of the EU member states that they should introduce some mechanism to enforce the employees' rights, so as sanctions, yes, for example, also, or some fines. During this webinar, I will not speak about the fines and the sanctions because I think we may not have time for it. We will just go through the mechanism and the obligations imposed of the directive and status of the implementation in Poland. First of all, Poland has not introduced the directive yet, and it is, for sure, I can say right now, we have 28th of May, we will not be able to introduce it, implement the directive by 7th of June. The first project of the statute, it's from last year, from 12th of December, but on 29th of April 2026, so 1 month ago, our government introduced new project. And this new project differs quite a lot from the initial project, and it's much more detailed. Right now, it's not in our parliament yet. It's still in the government at the stages of opinions and verifications. So it's still not in our parliament, not signed by the president. The project says that the implementation date, it will be 6 months since the announcement in our official journal. So just shortly, the way how the law is implemented in Poland. So firstly, it should be adopted by the parliament. Then it is signed by our president. And once signed by president, it is announced officially in the official journal. And since this announcement, since 6 months since this announcement, the law will be enforced in Poland. And so we may assume that this will happen in 2027, maybe since 1st January. We will see how it looks like. But nevertheless, provisions of the directive, they are quite detailed, and most of the employers should prepare right now. It's the high time to prepare to implement the pay structures, to start work on the pay structures, and also another procedures which will be required by the law, because the 6 months, it will be not a lot of time to implement the pay the provisions of the directive and of the pay transparency. One part of the law, as you may already know, it's implemented in Poland since the 24th of December 2025, and it concerns the recruitment stage, and it's already part of our labor code. So here, right now, I will speak about it shortly. First of all, the law introduces the rule that the candidate to work should receive the information about the initial pay or its range. Of course, it should be based on objective gender-neutral criteria. The initial pay or its range, it's understood not only as a base salary, but also the benefits, premiums, anything which is monetary or non-monetary, and the employee will receive it for the future employee will receive it for its work. Where applicable, also the candidate to work should receive relevant provisions of the collective agreement or remuneration regulation. So it basically concerns the employees which employ at least 50 employees. What is important, such information should be provided in such a manner that ensures that the negotiations are transparent for the pay. That the candidate to work will have like opportunity to negotiate the pay conditions. So it should be done a little bit earlier than in employment. So the possibility is that it will be visible in the job advert. And right now, from the experience, many job adverts, they already include the proposed salary, but still many do not include such proposal. If the proposed pay is not included in the job advert, then it should be provided to the employee prior to the job interview or prior to establishment of employment relationship at the latest. And it's not like an offer of a pay of future remuneration, but it should be an information. Yes, it's not so. It should be provided before the offer. And also the last obligation, but also very important, it's not visible as I see. It's not introduced in all of the job adverts. Still, it's that the employer shall ensure that the job advertisements and job titles are gender neutral, and that the recruitment process is conducted in non-discriminatory manner. So this is very important. In Polish language, we have differentiations between the men and women names of the work positions, and in the job adverts, it should be included both of these versions, or it should be somehow mentioned that the job advert it's not for men but also for women, or well, if you wish another genders. This is still discussed in Poland, but you can stick only to the men and women differentiation. What is the pay? These definitions, they come from the project of Polish statute implementing the directive. So first of all, there are two basic definitions, which is pay and pay level. You can find also the pay levels in relation to the hourly rates, but we will not go into such details during our webinar. Let's just discuss what is the pay. So basically, the pay includes all components of the remuneration, and the name of such component. It's not really crucial, and also the character. There should be included also work-related benefits, which are allocated to the employee in cash or in other forms than cash. So it can be base salary, bonuses, benefits, severance payment, and other benefits. Very important, another very important definition is the pay level, because this is something what should be provided to the employee. I will discuss it also later. So basically, the pay level is the gross annual remuneration, and this is calculated based on the actual remuneration received by the employee in a given period. What is important? According to the project of the Polish Act, it does not include, in particular, the same cash or in-kind benefits received by all employees or made available to all employees without any grounds for using them. Yes, so in case all of the employees in the company are entitled, for example, to medical treatment, this is it's very popular benefit in Poland, and the employees do not have to reach any, for example, they do not have to reach any seniority, and it's for all employees. It's attributable to all employees. Then we do not have to include such a component into the pay level. And the second component, which does not have to be included when calculating the pay level, are the benefits which are related to the termination of the employment relationships. When we are calculating the remuneration level for a given employee, then we should take into account the remuneration for the period the employee worked for a given employer in a given calendar year. So we take these amounts from the given calendar year. Another very important definition is the work of equal value, because the same work, it's easy to define. It's simply the same work, and work of equal value should be it's something which is assessed by the employer when the work it's of employees it's of the same value. Well, if we have one department of the company, for example, only marketing people. Yes, we have marketing company, and only marketing people are working for this company. Then it will be quite simple to say that, for example, people who are working on the same job position, they work it's of the same value for the employer. But usually in the companies, we have different departments like accounting, payroll, some specialists, consultants, and the definition of the work of equal value shall ensure that the employer is able to compare the work of people on positions between different departments. This is very important, and this will be necessary and very well needed in order to prepare the correct pay structures, and also later on to divide the employees into the categories of workers. So what is then the work of equal value? So this is work of employees whose value is assessed collectively on the basis of mandatory criteria, and the mandatory criteria are the skills, effort, scope of responsibility, and working conditions. Then can be also another sub-criteria or additional criteria established by the relevant for the relevant specific positions, or if we do not have positions in the company for the type for the type of work, and where this we make like the summary of the we assess the for each positions this at least this four mandatory criteria, then we will be able to grade the job positions and see between the departments what is the work of equal value. And categories of workers. This is also very important definition, which will be used by the employers. So basically, the employees which are performing the same work of equal value must be grouped by the employer in, of course, non-arbitrary manner, and in a groups. Yes, so we take this mandatory criteria, and once we assess all the job positions, then we can group the employees into the categories of workers. Let's move now to the obligations of all employers. Like in the directive, we have provisions which concern all of the employers, and we have also provisions which concern only the bigger employers which are employing at least 100 people. So each of the employer must know which provisions and which obligations concern them in case they employ less than 100 employees. And the first, the most important obligation, which concern all of the employers, is to prepare the pay structures. What I will talk right now, it's a little bit like I will repeat some information which I already told you about the value assessment of the value of work and categories of workers, but it is very important to understand what is the obligation. So the employer should prepare the pay structures. So this is like structured salary range for a specific positions or types of work within, of course, the given employer, and it should result primarily from the assessment of the value of work performed on a given positions or the assessment of the value of work on a given type of work. The salary structure may also be influenced by factors justifying differences in remuneration, including salary adjustment factors. So what is it? Basically, it should be like a table where we gather all the job positions in the company. So this will be the first step, how to prepare the pay structure. It's that we gather all the positions, or in case there are no positions, then types of work. But for now, let's assume that we have this, job positions. And first of all, we make assessment of the value of work on each job position. So in the first column, we have the job positions, and then the skills which I already the criteria which I already discussed. So the skills, effort, the scope of responsibility on the each job positions, we should assess it. So basically grade it, value it. So for example, we take a scale from 1 to 5, and on each job position we are making the assessment how it is of course for the employer, how it is how this skill is how this criteria is needed for the particular job position. So for example, for like a manager, we can say that the scope of responsibility, the number will be 5, and we assess each positions which we have in the company. Besides the mandatory criteria, we can also make sub criteria which are important, and and make this assessment, and in the end, of course, we make a sum. So we can, in the end, we can see that, for example, manager will have manager in legal department and in tax department will have, for example, the same number of points in the end, 55. yes, let's say. But this is, of course, an example. And then we can say that the value of the work is the same for the manager in legal department and the manager in tax department. So this is the first step, and this should be done in collaboration with lawyers, with HR department, but also with the managers of each of each department, because they know the best what is needed for each job position, what skill is, what effort is needed for each job position. So this is the first step. Mm, the directive also says that this criteria should be criteria for assessment, should be agreed also with the employees, and our if of course if possible, and our statute right now it introduces the obligation for the employer to consult and agree about this criteria for assessment with trade unions. And there is very specific procedure, quite long procedure, which is needed. So first of all, we should agree with all trade unions we have in the company, or if not possible, to agree with the representative trade unions. And within 30 days, we should make an agreement with the trade unions about the criteria for assessment. If it's not possible to do it within 30 days, then after considering the separate positions of each trade unions, the employer may apply the criteria which was introduced by itself until the agreement is finalized. And also the employer shall inform the labor inspectorate within 5 days of the date on which the criteria should have been agreed. Also, if the criteria are agreed, also the labor inspectorate should be informed. And this, of course, concerns only the employers which have trade unions. In other cases, the criteria does not have to be consulted with the employees. But as I said, this is only the project of the statute, and we will see how it will look like in the end. The next step, once we have the points, once we have graded, yes, the job positions, is the classification of the positions and establishment of the categories of workers which are performing the same work or work of equal value. And also this classifications should be consulted with trade unions within a period of no less than 7 days and no more than 30 days. But here it's a little bit simple, that if no agreement is reached, the employer shall carry out these actions independently after considering the positions of the trade unions. So we have made all the steps, and the final step is to assign the salary ranges to all the job positions. Here it is important, of course, to know what are the market conditions, and to check whether the salaries which we pay to our employees are comparable to the market right now. And so preparing pay structure is the first obligation. The second obligation is that the employers shall make easily accessible to the workers the criteria that are used to determine the workers' pay and also pay level. And also the last is pay progression. In case of employers which have less than 50 employees, they provide information about the pay progression factors only at the employee request. And such requests should be submitted in paper or in electronic form within 30 days of receipt of the request. So this is the second obligation, which shall be met by all the employers. Basically, we need to prepare some written, like it can be regulation, it can be information, what criteria are used to determine the pay level, and also the pay progression in our company. What is important is to know is that the right to equal pay for men and women, or for work the same work or work of equal value, it does not prevent the employers from paying differently for the same work of equal value. But of course, the difference must be justified and must be based on some objective gender-neutral criteria. For example, if someone is working for the work, it's working for the work of the same value, but it has the performance is better, or the competences are higher, then the pay can be different for the same work of the same value. So it's not the like the right that all the time, if we have people who are working on whose work is of the same value, that they must always earn the same money. There might be some differences, but these differences must be based on objective factors. So in case we are able to justify the differences, then there is no discrimination, and the employer is at safe position. So this was the second obligation, and the third one is the right to information of each employee. Namely, each employee has the right to request the information on their individual pay level, individual pay level, and also about the individual hourly rate or hourly pay level, and about the average pay level and average hourly pay level by gender. Yes, divided by gender for categories of employees performing the same work as them or work of equal value. So as you can see here, for the first time, we have this categories of workers, categories of employees used, and this is why the grouping into the categories of workers is needed. First of all, in order to ensure that this right of information will be enforced in our company. So the request of the and right now it is also the project of the statute. The provisions which I am right now presenting, these are about the current project. How this will look like in the end, we need to check the project. But right now, the position is that such request of the employee will be submitted individually or through a trade union representing the employee or an equality body, and that the employer will have 30 days to reply to the employee in writing or in an electronic form. Once a year, in accordance with procedures adopted by the employer should inform the employees about right to submit such request. And here the pay levels, also our government gives us some instruction how it should be calculated. In such case, the pay levels shall be calculated based on a 12-month reference period for which the remuneration was paid, preceding the month in which the request is submitted. So this is the third obligation, and here also the employer should introduce procedures, with the best written procedures, some regulation, how the employees can reach for such information, and of course such procedures should be constructed in accordance with current provisions. So the provisions which will be introduced, and also the employee will have rights in case the information is incomplete. So if this information received by the employee thinks that it's inaccurate or incomplete, then it will have, of course, the right to submit a request to the employer to in paper or electronic form for some additional explanation or detailed information concerning the data provided. And such requests may be submitted either individually by the employee or through a trade union. And also here, the employee shall have 30 days to reply in writing or in electronic form to such request. So this is this two. Well, this is the third obligation. Also, what is important to know is that our act provides, of course, the protection of the personal data, and the remuneration is considered as personal data, which is protected because this right to information, it does not give the right to employees to receive the information about the salaries of another worker, another employee. So based on this right of information, the employee should not receive, this is very important, should not receive information about the salary of another worker, another employee. And potentially, when could it happen? It can happen, for example, if in the categories of workers we have, for example, small category of workers and we have only 2 employees. So the employee which receives the pay level of his salary and then the average pay level in this category of workers, it will be very easy for him or her to calculate the salary of the another employee. And our government plans to, of course, to protect such situations, and in such cases, the information should not be provided to the employee, but to the trade union or another entity representing the employee, and such entity will be showing not the data, but informing whether the discrimination may be in place. But this procedure is changing from the statute to statute. So here we need to wait for the final version. But for sure, it will there will be mechanisms which will protect the employees of knowing and sharing the information about the salaries of another employee. So here it's employers should be on a safe position. Moreover, the forbidden provisions. What are the forbidden provisions which should not be included in the employment contract? So first of all, the employment contract or another regulation which is binding in our company should not prevent the employees from disclosing information about their own remuneration, in particular for the purpose of exercising rights arising from the non-equal treatment in employment. Yes. And this is not new, because our Supreme Court and the courts basically already stated such rule that the employee, in case is reaching his rights for equal treatment, so for non-discrimination, he is entitled to disclose his or her salary, even though the contract forbids such disclosure and says that this is confidential. So first of all, we cannot include such provisions in the employment contract. So the employment contracts should be reviewed by the lawyers or HR department to check whether such provisions are in place. So any provisions which prohibits such a right shall be considered as null and void. But the employer may require from an employee who has obtained somehow, yes, the information on this average pay levels and or the information about the remuneration of another employee, not to use such information for any purpose other than exercising rights arising from the principle of equal treatment in employment. So we can introduce such provisions, yes, that only the information about the average pay levels broken down by gender, that they can only be used by the employees to exercise the rights arising from the principle of equal treatment, not for other purposes. So this is all what is well, these are the bases, yes, the bases which concern all of the employers, notwithstanding of the number of employees employed by those employers. So just to make a short summary for all of you, what is needed. So first of all, to prepare the pay structures, and this, as I already said, should be prepared in cooperation with HR, lawyers, managers. Basically, the employer, they knows the best how to do the pay structure. First of all, we are gathering all the job positions. Then we make assessment of the value of a job at a specific job position. Then we create categories of workers, which is very important, and also assign salary ranges. So this is the first obligation. The second, it's to prepare and make available to all employees the criteria that are used to determine workers' pay and pay levels, and also pay progression. Third, it's to prepare the procedure for employees to exercise the right to information. And the fourth, I have not spoken about it yet, but it is also recommended to make an audit of the salaries and determine whether there are any pay gaps in our company. But the pay gap, if we have a pay gap, it's not like, it's not the factor which is determining that there is discrimination. Yes, we need to check. Maybe these pay gaps are justified. And but in case they are not, then there might be obligation to make the salaries the same. Yes, for the positions, for the job positions where the work is of the same value. So this making such audit also for the smaller companies is recommended, because the employees will get more mechanisms to enforce the right to equal pay for the work of equal value of the same work. Okay, so this was for employees. Now we will go to the employers which are employing at least 100 employees. And here, well, there are another definitions which are introduced by the directive, and which are important for all of the employees, but basically for those employers who employ at least 100 people. Well, first important definition is the gender pay gap. So this is the difference in average pay levels between female and male workers employed by the given employer. Here it's very very simple calculation to show, and it even, well, let's say, yes, that the pay level, so the annual salary is 5,000 euro for men and 4,000 euro for women. So how will we calculate it? We deduct the from the salary pay level of men, the pay level of women, and we divide it by the salaries of men, and we multiply it by 100%. So in our example, when we have 5,000 to 4,000, the pay gap would be 20%, so very high. And if not justified by gender neutral criteria and objective criteria, then we may have the discrimination in our company, and basically we should do something. We should do something with it. For example, make the salaries the same. Second important definition is the median pay level. So what is the median? Is the pay level at which half of the workers of an employer earn more and half and less. Why median is used? Because, like, simple average salary in the whole company, it may not show us the real situation. If the company, for example, if we have like manager who is earning a lot and people who are earning like the minimum salary in Poland, then we will have the result will be that the average salary in our company is rather high, but in fact most of the people are earning very little. So that's why this median is it's used. So here in the example, there are pay levels for each salary for each job position, and the median will be 6,000. So half of the positions earn more and half earn less. If we have, for example, because here we have five type of salaries. If this will be, for example, 6, so we cannot make simply the median. So we take 2 and we the two in the middle, and we divide it by 2. The second definition is median gender pay gap, which means basically the difference between the median pay level of female workers and the median pay level of male workers of an employer, and this is also expressed as a percentage of the median pay level of male workers. So it's calculated basically as the pay gap, which I shown before. We just take the median pay levels as the numbers. So why it's important? It's important because the employees which are employing at least 100 people will have certain reporting obligations. The scope of information, it's on the slide here. Maybe I will not like read all of these. The presentation will be provided. This is the same for the directive, the same for the act right now. Well, as you can see here, we have the gender pay gap. We have also the median gender pay gap, but also the gender pay gap among employees, which are divided into the categories. Yes, so gender pay gap among employees by employees categories, and based on basic hourly or monthly pay and complementary or variable components. So this will be very specific, very specific scope of information, which should be provided, and we should have like tools which will allow us to make easily the calculations of those information. And the deadlines. Well, we will see when the law will be introduced, but it is right now. It should be the first reporting should be done in 2007 for 2026. So right now, well, these are like the directive deadlines right now, but our government plans that the reports would be submitted earlier than 7th of June 2027. but in March. So the biggest employees employing at least 150 employees will have the right, will have the obligation to report in 2027 for the year 2026. So already in this 2026, these kind of employers should already make yes an audit whether there are pay gaps, some pay differences, and what does it mean for the company. Smaller employers which are employing from 100 to 149 employees will be required to submit the report in 2031 for the 2030, and then every 3 years. Employees employing at least 250 employees will present such report annually, and the employers employing from 150 to 249 employees will present such report every 3 years. How we will calculate the number of employees. This is also right now the proposal of the statute of our act. So we will see how it will look in the end. But basically, the number of employees should be converted into annual work units, yes, in a given calendar year. And for example, temporary employees shall be also included in the numbers if they are working for us. Yes, so we are like the user of the temporary employees, and they are not counted by the temporary work agency themselves. So this is important, and here it's the from the provisions, the way how to convert an employee into an annual work unit does not sound very good. Yes, this annual work unit, but it is what we have. So in case the employee work the for full months, we have this formula. Yes, so we have a number of months, divided by number of months in the year, and working time coefficient. And there are incomplete months, then we are taking the number of days, and number of days dividing by number of days in a year. So this we will also provide to you, so you can check how the annual work units, what is right now the proposal, how to calculate it, and we take right now only employees, not the mandate contracts or some B2B agreements. Right now the employees are only taken into account. And last obligation of such employers, so it's to make the joint pay assessment. So this is this should be made between with cooperating employers should cooperate with workers' representatives. And this is made basically when we have pay reporting and demonstrates average pay level, a difference in the average pay level between female and male workers of at least 5% in any category of workers. And such difference is not justified on the basis of objective gender neutral criteria. And also the employer has not remedied such unjustified differences within 6 months from the date of submissions of the pay report. The elements of the joint pay assessment, I will not read it all. You will have the presentation, but you can see it's quite a lot, and this is also like additional obligation and regulation how to make it, if we have no trade unions, so how to the representatives should be elected of the employees. Then there are many factors which should be taken into account. And this joint pay assessment should be available for the workers and workers' representatives, and also submitted to the monitoring body. And employers, of course, are required to take appropriate remedial measures to minimize the pay gaps, gender pay gaps, and that's basically what I wanted to say today. And we have some time for Q&A, so I will check whether there are some questions and whether I am able to answer these. Okay. I see there are some. Okay. Because I see that I think that I have answered some of these questions during the webinar, and sometimes I do not know which part it concerns, because we are saying about pay and pay levels and different types. But for example, I have a question. Giuseppe is asking, can performance of the employee be an objective criteria? So basically, and I was already saying about this, that if we have for the job positions, we found out that the work is of the same value, but there are differences in pay even between, for example, the same job positions, then yes, there was an example that the performance competence, it can be an objective criteria for making differentiation between the salaries of men and women. So I hope I answered this questions. And I have a question. What about employers with less than 100 employees, for example? So here I think that it is meant what about the reporting? So because I see it's in in the end. So if employer has employees with less than 100 employees, then and then in such case, there are those three obligations which I have spoken in the beginning of the presentation, and such employers, they do not have reporting obligations, and but they may do it if they want. They may make reports. For example, some employers would like to be transparent towards the employees, so the making such report, it's needed for them, or the employers who know that they will reach the level of 100 employees soon, or in some future. It is also what to prepare for, already prepare for these calculations of the pay gap and all the on another reporting obligations, informations which were sorry, which were already provided by me. Also, does the number of people employed includes full-time positions? It includes, all positions, or we should include civil law contracts. So right now, civil law contracts are not included. It's not included. Okay, so please, if you have, I think. Yes, Sylvia. So only contract of employment. So it's we have 12, so we reach the time. We will gather these questions, and we will prepare our written answers. I think within well, 2 weeks. And if you have some questions, please send it to us. I'm sorry, we should have contact details in the end of presentation. And because sometimes I do not know to which part of the presentation the question relates to. For example, there was some question about the pay. It was in the beginning, but I have mentioned the pay and pay levels few times. So in case you have already asked some question, you may also send this question one more time to here is the contact, but also at the beginning you should have direct contact to me. Just check it. If not, we will add it. Yes, here is the direct contact. As you can see, it's direct contact. It's direct contact to me. So please send it, and we will be happy to answer. I think we will also publish it, the answers on our webpage, and we will be happy to answer all the questions. So thank you very much for participating in this webinar. In case of, as I said, in case of any questions, then of course please contact us, and we will be happy to answer. I would like to wish you the rest of the day.